The judge stopped mid-sentence, not gently, not politely. His hand lifted, palm open, and the entire courtroom froze with it. The clerk's fingers hovered above the keyboard, suspended mid-air. The bailiff straightened instinctively, as if bracing for an instruction that hadn't been spoken yet. Even the low murmurs from the back benches cut off at once. "Hold on," the judge said, his voice level but unmistakably firm. "This doesn't line up." No one responded. I stayed exactly where I was, my hands folded neatly in my lap, shoulders relaxed, eyes forward. I didn't look surprised. I didn't look confused. I had learned long ago that stillness unsettles people more than protest ever could. I had known this moment would come. I just hadn't expected it this early. The silence stretched, uncomfortable and heavy, pressing down on the room. Beside his attorney, my husband shifted slightly in his chair. It wasn't panic, not yet, but something closer to irritation, like a man realizing a meeting was taking longer than planned. 2 rows behind him, she leaned forward. She wasn't supposed to be there. Her heels clicked once against the courtroom floor as she crossed her legs, slow and deliberate. She sat too close, close enough that her knee nearly brushed the back of my husband's chair. No one stopped her. No one corrected her. Her hand rested lightly on the back of my husband's chair, a gesture that was unmistakably familiar and entirely unnecessary. Public, possessive, intentional. She smiled at him, not broadly, not nervously, but with the quiet confidence of someone who believed the room belonged to her. I said nothing. The judge flipped a page in the file, then another. His expression didn't change, but the atmosphere did. Something shifted. Subtle, almost invisible, but once it moved, it couldn't be ignored. "Counsel," the judge said, eyes still on the paperwork, "before we proceed, I need clarification." That was when my husband turned and looked at me, not with anger, not with concern, with annoyance, as if I were a delay, a procedural inconvenience standing between him and the outcome he expected. This hearing had been scheduled as uncontested. No witnesses, no arguments, clean, efficient, forgettable. That was how he had framed it, to his attorney, to his family, to her. I met his glance briefly and then looked back to the bench. The judge raised his eyes. "Mrs. Carter," he said, reading my married name from the file, "do you recognize this document?" "Yes," I replied calmly. My voice didn't waver. The clerk glanced up, just for a moment. "This signature," the judge continued, tapping a single page with his finger, "confirms acceptance of the financial disclosures submitted by your spouse." I nodded once. That's what it states. The judge didn't return the nod. Instead, he tilted the document slightly, studying it again. "And yet," he said, slower now, "the filing date here precedes the marital separation." The room went still again, but this time it wasn't orderly. The clerk's fingers resumed typing, faster now. The bailiff shifted his stance. My husband leaned toward his attorney, whispering something under his breath. Behind them, she straightened sharply. "That's incorrect," my husband's attorney said quickly, rising halfway from his seat. "Your Honor, if I may clarify." "Not yet," the judge said, without looking at him. The attorney sat back down. Her smile disappeared. She leaned forward again, this time closer to the aisle, and whispered something toward my husband's attorney. It wasn't loud, but it was confident, as though she expected to be heard. The bailiff took one step toward her. I kept my gaze forward. The judge turned another page. "According to this record," he said, "the acknowledgement was finalized before marital separation was legally documented." He paused, let the words settle. "That is usual." No one spoke. My husband's jaw tightened. He stared straight ahead now, hands clasped together, his earlier ease replaced with something sharper, less controlled. The judge adjusted his glasses and finally looked up at me again. "Mrs. Carter, have you had independent legal counsel review these documents?" "Yes," I answered. My husband turned so fast his chair scraped softly against the floor. "When?" the judge asked. "Recently," I said. Not defensive, not explanatory, just factual. The judge nodded once. He didn't smile, he didn't frown. He simply closed the file partway and rested his hand on it. "We're not proceeding yet." A low ripple moved through the courtroom, quiet voices, shifting weight, restrained curiosity. She stood abruptly. "Excuse me." The bailiff was beside her instantly. "Ma'am, you'll need to remain seated." She froze, eyes wide for half a second before she masked it. The judge didn't look in her direction. "This court will address parties of record only." My husband didn't turn around. He didn't look at her. His attention stayed fixed on the bench, his posture rigid now, as if movement itself had become risky. The clerk received new instructions, original filings, timeline verification. The room no longer felt routine. It felt careful. I exhaled quietly, my expression unchanged. The judge leaned forward slightly. "There are questions here that need answers." He looked at my husband, then back at me. "We'll take this one step at a time." The gavel did not come down, but nothing moved forward either. And as the courtroom remained suspended in that unresolved moment, one thing was clear, even if no one said it out loud. The story they had prepared was no longer the only one on record.
The clerk didn't look at me when she spoke. She kept her eyes on the screen and slid the folder closer to my husband's attorney instead, as if that were the natural direction of things. Papers moved across the table without passing through my hands. Dates were referenced, amounts were read aloud. I listened to numbers that once belonged to both of us become his by default. No one asked if I had questions. The judge had already continued the matter, not dismissed it, not resolved it, just paused it in a way that felt heavier than a ruling. The room exhaled and then moved on, like the interruption had never happened. My husband leaned back in his chair, relaxed, confident. He didn't look at me once. His attorney spoke smoothly about cooperation, about efficiency, about how clean the filings were. Words like standard and routine floated through the room, repeated often enough that they began to sound like instructions instead of descriptions. When the judge asked if both parties were prepared to proceed once records were reviewed, my husband's attorney answered immediately, "Yes, Your Honor." I wasn't asked. I stayed quiet. That silence followed me out of the courtroom and into the narrow hallway where people waited for their names to be called. My husband stood close to his attorney, their voices low. The woman who had been seated behind him earlier stayed with them, not stepping away, not pretending she didn't belong. She spoke to the attorney like she had every right to. No one corrected her. I took a seat on the bench opposite them. Hard wood, cold surface, the kind that makes you aware of how long you might be sitting there. I folded my hands together and waited. A court staff member approached me with a clipboard. "Just need you to initial here," she said, already pointing to the space. I looked down. It was a summary of disclosures, assets listed in neat columns, accounts closed, properties transferred, dates finalized. I didn't recognize some of the timing. "Is this the full record?" I asked. She hesitated for half a second, then smiled, polite but tight. "This is what's on file." On file. I initialed where indicated and handed it back. She moved on without another word. Gaslighting doesn't always come as denial. Sometimes it comes as paperwork that assumes agreement before you're given space to question it. In the waiting area, my husband finally glanced in my direction, just once, long enough to register that I was still alone on my side of the room. He smiled, not warmly, not cruelly, just certain. I heard him say, "She already signed," to his attorney. No one challenged that statement. A bailiff announced that the courtroom would reconvene briefly for procedural scheduling. We filed back in, the same seating, the same separation. The judge confirmed timelines and deadlines, emphasizing efficiency, emphasizing closure. Every word pressed down. I was referred to as the other party, as she, as a name attached to a file number. Decisions were framed as favors. Delays were framed as inconveniences. At one point, my husband's attorney said, "This has already been finalized administratively." Administratively. The word stuck. I noticed the judge glance at the clerk. Not long, just enough. The clerk nodded, then looked back at her screen. Nothing was said out loud. The hearing ended with instructions to submit updated records within a specified time frame. No explanation for the earlier interruption, no acknowledgement of it at all. Outside the courtroom, my husband stood in front of me for the first time that day. "This doesn't need to be difficult," he said, quietly, like he was offering advice instead of control. "You don't need to slow things down." The woman beside him didn't look at me. She checked her phone. I didn't respond. He waited, expecting something, a reaction, a protest. When it didn't come, he frowned slightly, then turned away. I walked out of the building alone. The pressure didn't lift once I was outside. It followed me into phone calls that evening, emails from attorneys written in language that assumed consent, messages reminding me of deadlines I hadn't agreed to. Just confirming receipt, standard process, nothing unusual. Each line pressed the same message into place. This was already decided. I read everything carefully. Dates repeated themselves, numbers aligned too neatly. A specific transfer showed as completed before the separation timeline I remembered. I didn't confront anyone. I didn't correct the emails. I didn't ask questions that would alert anyone. Instead, I saved copies, printed others, labeled folders the way I always had, even when it felt pointless. The pressure came quietly, in reminders and expectations, in the way people spoke to me like resistance would be irrational, like silence meant agreement. I let them believe that. Late that night, I opened one document again, the same one the clerk had summarized so casually. I read it slower this time. One line didn't match the rest, just one. I closed the folder and set it aside. The next hearing date was already scheduled, and this time I knew exactly what they thought I didn't have.
The hallways after the hearing were quiet, almost sterile. Footsteps echoed against the marble floor as staff and attendees moved past, leaving pockets of silence in their wake. I followed the familiar pattern, keeping a neutral face, letting others assume I was disengaged, distracted, compliant. That was the illusion I needed, the perception that I was still merely a participant in their narrative, not someone quietly recalibrating the scales of authority. By late evening, I found myself at my kitchen table, the weight of papers and folders forming neat, almost mechanical stacks before me. Nothing dramatic, no frantic sorting, just methodical, clinical organization. Every financial record, every filed statement, every document from the prior hearings, each was carefully scrutinized, checked against timelines, cross-referenced for signatures and dates. My pen hovered lightly over annotations. I made no conclusions, only noted anomalies. And there it was, a minor inconsistency, subtle but unmistakable. A signature had been finalized a day earlier than it should have been. No one would catch it on a casual read. It wasn't enough to scream error, but enough to set a calculated observer on alert. I made a note, folded the paper precisely into its place, and moved on. Over the next few days, the process repeated. I maintained calm and correspondence, acknowledging receipt, complying on the surface, but all the while noting procedural shortcuts and subtle misalignments. The staff, the attorneys, even my husband and his new wife, all remained comfortably overconfident. They assumed familiarity with process equaled control. Confidence, as I had observed, often breeds carelessness. The new wife continued her quiet incursions. She wasn't merely present, she acted as though her authority extended beyond the ordinary boundaries of a witness or observer. She adjusted documents in front of clerks, whispered brief instructions to attorneys, glanced over my files with the faintest smirk, and even positioned herself where protocol suggested she should not. On any casual observer, these actions seemed incidental, almost polite. But in the context of authority, these micro-assertions revealed arrogance and presumption. I observed, noting each one without emotion, recognizing them as both a hazard and an opportunity. I scheduled a consultation with a legal advisor, deliberately brief, clinical, and focused solely on fact verification. I presented all gathered documentation in neutral folders, describing timelines without judgment, avoiding commentary on intent. Questions were methodical. Does this sequence comply with procedural requirements? Are these filings consistent? Do any dates conflict with notarization or verification protocols? No argument, no dramatization. The response was measured silence, a recognition that meticulous observation had surfaced something worth their attention. Meanwhile, small procedural microspikes continued to present themselves. A misfiled document here, a clerk's hesitant pause there, a minor contradiction whispered between attorneys, all unnoticed by others, but immediately recorded by me. Each was a reminder. Authority can be quietly corrected, not just confronted. I kept these notes meticulously, a silent ledger of potential leverage, a roadmap toward inevitability. Even daily routines became part of the preparation. I returned documents to secure folders with deliberate precision, placed items in the order they would be reviewed, tested their accessibility, and monitored reactions when they were handled by staff. Subtle, controlled, entirely legal. Every small misstep by others accumulated as evidence of overconfidence, a pattern that would become undeniable when presented correctly. Observation alone was not enough. I also implemented preventative measures, copies of every interaction, time-stamped correspondence, secure logs of phone calls. No overstatement, no dramatics, only factual preservation. The reality of legal proceedings is that unarguable facts outweigh narrative flourish. I relied on this principle, quietly reinforcing my position without revealing intent. The days leading up to the next hearing were punctuated by small but deliberate tests of the system. I submitted forms with precise timing, noticing when my husband's counsel skipped steps or overlooked attachments. The new wife's micro-assertions became increasingly visible, touching files before clerks could, giving minor instructions, even subtly questioning attorneys in the hallways. Each act of presumption became a documented observation, silently reinforcing the imbalance of perceived control versus actual authority. In one instance, a document nearly went missing. A clerk had misplaced critical filing, unaware that I had a duplicate copy. I noticed instantly, calmly corrected it, and allowed no comment. My heart did not race, my voice did not rise, and yet the internal satisfaction was unmistakable, another near miss that would later demonstrate the carelessness of others. Night after night, I reviewed, reorganized, verified. No panic, no emotional reaction, just the rhythm of methodical work. Each time I closed a folder, stacked it neatly, or locked it away, the sense of control deepened. My presence in the courtroom would soon reflect this preparation, but for now, the power lay quietly in files, notes, and unspoken patterns. I also reviewed prior hearings and testimony. Each phrase my husband or his counsel had used, each subtle assumption, each procedural misstep, all cataloged. Nothing was discarded. Every overlooked detail was a potential pivot point for the approaching authority confrontation. The courtroom would be impartial, but facts, when properly presented, have their own language of all. Subtle tension threads threaded through these preparations. I noticed a minor discrepancy in financial disclosure, a signature slightly altered in notarization, a date misaligned with submission records. Individually, these would appear trivial. Together, they formed a cumulative signal, an unavoidable hint that control had been assumed, not earned. I cataloged these quietly, without comment, ready to present them at the right moment. Through it all, I maintained the same calm demeanor externally. Staff assumed compliance, counsel assumed distraction, my husband assumed frustration or disengagement, the new wife assumed superiority. In truth, I was fully present, fully aware, fully prepared. My silence was deliberate, my patience a strategic tool. By the end of Part 3, the foundation for the coming confrontation was complete. Every record, every anomaly, every observed misstep, every subtle assertion of arrogance by the opposing party was quietly documented, verified, and preserved. The slow burn shift from powerless observer to quiet authority was no longer subtle, it was inevitable. Once documented, the records spoke for themselves.
The courtroom was quiet, but not in the ordinary way. The low murmur of paper shuffling and soft footfalls seemed to halt mid-motion as the judge leaned forward, his fingers hovering over a stack of files. "Bring me the financial disclosure from March 21st, he said, his voice calm but immovable, cutting through the room like a scalpel. Everyone in the room froze, lawyers, clerks, even the gallery, but I remained still, quietly watching, letting the silence deepen the tension. The clerk hesitated, flipping through a tall stack of paperwork, clearly unsure. My husband shifted in his seat, a subtle tightening of his jaw betraying his confidence beginning to waver. The new woman at his side, usually poised and smug, glanced around nervously, her fingers brushing against the edge of his chair. I observed them both without a word, noting the tiny micro-reactions, the unspoken panic that hadn't existed before. The judge's gaze lifted slowly, scanning the room. "This document appears notarized on a different date than indicated on the filing," he continued, his tone neutral but pointed. A murmur ran through the attorney's tables. My husband opened his mouth to interrupt, but the judge's raised hand froze him mid-sentence. His dominance was subtle, but absolute. No one could speak without permission. The room felt smaller, the air thicker, as if every individual was suddenly acutely aware of the authority in the space. I didn't flinch. I didn't need to. The records I had prepared in silence, the discrepancies I had quietly catalogued over weeks, were now the instruments of their undoing. My mind traced each document's path, each date and signature, visualizing the exact sequence that would validate the anomalies. I had seen this moment coming, anticipated it, and nothing in their confidence could alter the inevitability of the evidence. The judge continued, his eyes narrowing slightly at the clerk. "Please verify the chain of custody for this document. I want a clear TI." The clerk scurried, flipping through files and digital logs, the tension evident in her movements. The new wife whispered something to my husband's lawyer, a small, restrained attempt to regain control, but it was already too late. Their gestures of dominance, once so assured, now appeared clumsy, reactive, almost desperate. The quiet was mine to occupy, a silent claim over the unfolding proceedings. A minor commotion arose when the clerk's fingers paused over a misfiled page, almost discarding it among unrelated forms. I noticed immediately, leaning slightly in my seat as if examining the document for the first time, my face betraying nothing. Without speaking, I guided the clerk's attention by the tiniest of gestures, ensuring the evidence was correctly presented. A near miss, almost invisible, yet critical in maintaining the integrity of what was about to unfold. My husband's lawyer finally spoke, voice tight, cautious. "Your Honor, if I may," the judge raised a hand again, stopping him without need for explanation. Authority wasn't just present, it was living in every pause, every gesture, in the careful unfolding of documents. I could feel the tide shift. The very system that had once felt oppressive now became a shield, an ally, an invisible hand asserting truth over arrogance. The new wife adjusted a chair slightly, encroaching into the attorney's workspace, whispering instructions. Observing her, I catalogued this as yet another display of overconfidence. Each subtle misstep, the minor assertiveness, the misplaced confidence, would work in my favor, and I remained composed, letting their gestures expose the fragility I had long suspected. The judge finally spoke again, decisively. "I will require the notarization records and supporting evidence for verification immediately. Ensure the original filings are cross-referenced with all supplemental materials." There was no urgency in his voice, only the quiet insistence of authority that could not be ignored. The room stiffened. Lawyers murmured to clerks, papers shuffled frantically, yet I remained a silent observer. For the first time, I saw genuine concern in my husband's eyes, subtle but unmistakable. He had always relied on confident assumption, assuming compliance would carry the day. Now, compliance alone could not shield him. The records I had gathered, each quietly verified, each anomaly carefully logged, were about to speak, and the authority in the room would heed them without bias. As the clerk gathered the notarization logs, I noted the moment the judge glanced at me brief, almost imperceptible. He recognized that someone in the courtroom understood the significance of the discrepancies, someone who had observed, prepared, and positioned herself for truth to prevail. I didn't look away, my calm a deliberate signal of awareness and readiness. The power shift, though silent, was palpable. The new wife finally realized she could no longer influence the room, the edges of her confidence fraying as the judge's requests became more pointed. A slight tremor in her hand as she touched the table, a fleeting hesitation in her posture, tiny cracks in her composure that mirrored the slow collapse of the image she had projected. Observing without interference, I allowed the weight of authority and procedure to guide the next steps. The judge reviewed the records meticulously, connecting each dot, verifying dates, signatures, and supplementary filings. Each correction, each confirmed inconsistency, reinforced the quiet, methodical work I had carried out in private. The power wasn't in a confrontation, it was in the procedure, in letting facts emerge under the scrutiny of an impartial system. By the time the judge concluded his review, my husband's once assured demeanor had dimmed, replaced with a subtle tension and unease. The new wife, seated next to him, slumped fractionally, her previous poise now muted. Their arrogance, displayed openly in Part 1, was now overshadowed by procedural clarity and the authority that could not be argued with. I remained composed, letting the unfolding reality speak, letting the system validate my quiet preparation. Finally, the judge spoke, calm, measured, authoritative. The records showed discrepancies requiring amendment before finalization. Further, all notarizations must be corroborated with original filings, effective immediately. No celebration. No gloating. Just the undeniable affirmation of truth, documented, procedural, inescapable. I exhaled slightly, a release almost imperceptible. The silence in the courtroom now carried weight. The preparation I had carried out in hidden hours, the small observations, the careful cataloging, all converged to this moment. Authority, facts, and patience had done what assertion alone could never achieve. Every glance, every document, every micro-reaction confirmed the power shift. The courtroom, once a stage for public humiliation and tension, now quietly reflected justice, not dramatic, not overt, but inevitable. I remained seated, calm, factual, letting the documents and the judge's authority narrate the truth. Because once verified and corroborated, records do not lie. Authority, when properly engaged, cannot be swayed by confidence or intimidation alone. The power had shifted, quietly, irreversibly, and I was ready for the next steps that would finalize the outcome.
The room held a quiet tension, the kind that made every footstep echo in my ears. The judge leaned forward over the desk, eyes scanning the carefully organized stack of documents before him. Each page had been cross-checked, verified, and methodically arranged. Nothing was left to chance. I sat motionless, letting the authority of the court take center stage. My husband shifted in his chair, trying to maintain composure, but the flicker of unease in his expression betrayed the cracks in his confidence. Beside him, the new wife fidgeted, adjusting her posture, whispering faintly to the attorney, her attempts at control barely masking the rising tension. The judge called for the final verification of the financial disclosures, a step that had been quietly prepared over weeks. Each line of evidence confirmed what I had quietly anticipated. The discrepancies, the altered dates, the notarization inconsistencies, all now held the undeniable weight of legal authority. The room, which had been heavy with expectation, now carried a different energy. Authority had aligned with fact, and no amount of charm, whispering, or entitlement could alter it. I remained still, hands folded, letting the documents speak louder than any words I could have uttered. As the judge reviewed the marital records one last time, he asked pointed questions to my husband's lawyer, questions that required careful explanation and verification. The attorney stumbled slightly, fumbling through cross-references, while my husband's confidence waned visibly. The new wife's previously assertive posture softened. She was no longer the dominating presence she had been at the beginning of the hearing. Every glance she cast in my direction lacked its prior confidence. It was subtle, restrained, and utterly factual. The room now reflected the reversal I had silently prepared for. The court clerk brought forward the final amended filings, each one meticulously numbered and ordered. I observed the process with quiet attention, noting the precise way in which the authority figures executed their responsibilities. There was no spectacle, no drama, no vindictive commentary, just law and order asserting itself. This was the moment the careful patience, the quiet endurance, and the methodical preparation had led to. Each document, each verified record was a testament to the silent work that had occurred behind the scenes, unnoticed by those who had underestimated the situation. Finally, the judge spoke, calm and resolute. The words were measured, precise, and utterly indisputable. All previously submitted discrepancies were acknowledged and corrected. Authority had confirmed the factual records, and the legal outcome was declared. I did not need to speak. The law, the documented evidence, and the careful preparation had done all the work. My husband's posture sagged, his attempts at posturing nullified, and the new wife sat silently, her earlier entitlement quietly eroded. The courtroom, once filled with tension and subtle humiliation, now resonated with the finality of procedural justice. I allowed myself a quiet breath. This was not gloating. There were no pointed remarks, no emotional outbursts. The satisfaction was internal, calm, and undeniable. I had endured the humiliation, observed with precision, and prepared in silence. Every small act, the careful review of documents, the organized evidence, the patience in waiting for the authority to act, had culminated in a clear legal victory. The reversal was complete, earned through knowledge, not confrontation. As the judge closed the session, the authority of law had spoken for itself. The decision was final, procedural, and unassailable. My husband and his new wife collected their belongings, their previous dominance reduced to mere formal presence. The room had returned to its standard rhythm, but the echoes of justice lingered, subtle yet undeniable. I stood, collected my own materials, and moved with composed dignity, each step a quiet assertion of the strength I had maintained throughout. Outside the courtroom, the world felt unchanged, yet everything had shifted. No one could dispute the outcome. No one could challenge the authority that had verified the truth. I walked away with the knowledge that patience, observation, and legal preparation were more powerful than any dramatics or entitlement. The reversal was complete, inevitable, and grounded in fact, not emotion. My dignity remained intact. The humiliation of the past moments transformed into silent acknowledgement of justice. I did not need to celebrate. The quiet strength of the procedure, the meticulous verification, and the undeniable authority had spoken louder than any words. Every act I had taken, every document prepared, and every observation made had led to this inevitable conclusion. In that moment, I understood the power of silence, patience, and law. The courtroom was no longer a stage for personal posturing. It had become the vessel of undeniable truth. And as I stepped into the corridor, leaving behind the echoes of authority and the residue of public tension, I carried a calm satisfaction, a quiet victory. There was no need for gloating. There was no need for demonstration. The law had spoken. The records had confirmed. My strength, grounded in preparation, restraint, and observation, had prevailed. Silence, dignity, and patience were the ultimate victors.